Basically deals with the crime of fleeing law enforcement and the crime of resisting arrest and carjacking. And essentially, if you go through the section 1 deals with fleeing law enforcement and motor vehicle resulting in bodily harm and increases that minimum sentence from its current 3 to 10 years. Then fleeing law enforcement and motor vehicle resulting in the death of a person, it increases the minimum sentence from 5 years to 20 years. There's no change on the failure to yield to law enforcement officer. It's still a misdemeanor, and upon conviction shall be punished by a fine not to exceed $1,000, imprisoned in a county jail for a term not to exceed 6 months in jail. But then reckless or willful disregard for safety, becomes a felony under this bill, and upon conviction thereof shall be punished by a fine of not to exceed $5,000 or by commitment to the custody of the MDOC for not more than 5 years or both. Then section 2, resisting arrest, it makes it a felony and increased sentencing from county jail to MDOC and not more than 2 years. And finally, the section 3 deals with carjacking, includes a minimum sentence for carjacking to not less than 5 years, a maximum of 15 years, and includes a minimum sentence for armed carjacking to not less than 10 years, a maximum of 30 years. That is a summary of what the bill does. I'll be happy to answer any questions. Yes, sir. Senator Sparks.
Thank you, Mr. Chairman. I see the area where we are proposing to go from 3 to 10 and 5 to 20 in section 1. I may have misunderstood. I thought you mentioned a 5-year issue on one of them. I think see that section.
I think this stays the same. I think that's on lines 33 and 34.
Oh, okay. I'm sorry.
That's not a change. I was just, in case someone hadn't read the bill, I wanted them to know what the law was, but we did not change that section in this bill.
And then in section 2, this is what would typically be deemed as a felony fleeing. In other words, you have failure to yield to blue lights, which is the misdemeanor that you referenced.
Yes, sir.
Then section 2 would be the heightened level that they say in the determination of the affidavit that you fled from me.
Right.
That's a mandatory 2-year sentence. Is that correct?
Yes, sir. No, wait a minute.
Just not more than.
Not more than 2. Yeah. I think what was deleted on line 61 was 6 months. And it is changed from 6 months to 2 years on line 61.
Okay, so we changed it from a misdemeanor to and I apologize, I should have looked at a strike through version, but
no.
Where I see the word felony underlined, did that have misdemeanor? Is that the word?
Yes.
Okay, because the 6 months would have been a misdemeanor.
Would have been a misdemeanor, yes, sir.
Okay. What? This is for resisting arrest. This is not the moving car incident here.
On section 2, resisting arrest. Yes.
Okay, thank you.
Yes, sir. Good questions. Any other questions? Senator Turner Ford, yes.
Thank you, Mr. Chairman. Yesterday, we took up this bill that relates to stealing of a motor vehicle. And so now today, this bill includes carjacking. How is that different from theft?
I'm not the expert, but I believe it deals with the use of a weapon, perhaps, in taking of the vehicle versus just stealing it off the street.
Is that defined?
I'll defer to one of our prosecutors here.
Right.
Yes.
Carjacking is by the use of force. So you have armed carjacking, which is the use of a weapon of some kind. Regular carjacking is if you throw somebody out, do that. And then stealing of a vehicle is nobody's in the vehicle. So it's just taking the vehicle. And the carjacking has somebody in the vehicle. Carjacking is somebody's in the vehicle at the time.
That's it. Thank you.
So my next question is, so I understand that we're increasing the minimum.
Yes, ma'am.
What is the basis for doing that?
The basis of doing that, again, I think goes to the fact that in many instances, especially in the Metro Jackson area, you have judges, once the prosecutors bring these cases in front of them, will issue a sentence, but will then suspend all or most of that sentence. And so you'll sentence someone to say, 5 or 10 years, and then you'll suspend the 5 or 10 years, basically as a warning that if you do this again, I may not suspend your sentence, but it's basically a warning. And I think the thought being this is such a violent type situation and it's become so prevalent in this area that we don't want judges completely suspending the sentence.
So is the, if this bill passes, is the judge prohibited from allowing the person to be sentenced to MDOC, but yet they are on some sort of probationary status? It's not mandatory incarceration.
No, it's a minimum sentence of, depending on which of these crimes you're talking about, there's simply a minimum sentence entered, not that you can't suspend the entire sentence, in other words. So it would be jail time.
Mandatory incarceration.
Yes.
So how does, if the previous minimum is 3 years, and we're now increasing it to 5 years, how are these judges able to allow these suspended sentences simply by changing the minimum amount?
I don't know the answer to that question. That's the explanation I've been given. Senator Hill?
On the minimum sentence where it talked about imprisonment and I think, in question for counsel, and I think we have some statute that says that house arrest is considered incarceration. Senator Wiggins is shaking his head. So this would not necessarily mean, even if they couldn't get a certain portion of their sentence suspended, this would still not necessarily mean that they would be locked up. Is that correct? That they could be.
I'll defer to our prosecutor friends.
I'm sorry, the question.
I said, could the judge still sentence him to house arrest under this mandatory minimum and not lock him up?
Under carjacking?
Pardon?
Right, it generally,
okay.
a violent offense is not eligible for
Okay.
house arrest.
So they would definitely be incarcerated.
Right,
Thank you.
I
Appreciate
think
it.
the question that the Senator Turner Ford has asked, which is a good one, is are judges currently with like a 3-year minimum sentence, are they allowed to completely suspend that sentence of 3 years? Or is there some sort of time that has to be served? Senator Sparks?
Thank you, Mr. Chairman. I think that is probably the concern is we can raise the minimums on all of these issues and not to pick on the jurisdiction which we are, but the stats show out where the crimes are occurring. Then the DAs and the other districts across the other counties have to deal with this as mandatory minimum. And the concern is that they continue to be suspended where the suspensions have happened and people in other districts get locked up for longer. And that's not the target. But I think the short answer is the judge can suspend the sentence, could give 20 years and suspend all of it. And in the past, maybe 3 was the max that they could, or as low as they could go. But I think they can suspend it. May I parlay that into a question also?
Sure. Yeah.
Which takes me back to section 2. We have taken away a misdemeanor resisting arrest and made it now a felony. There are 2 things that happen at arrest, particularly when you're not compliant. If someone says, Mr. Sparks, put your arms behind your back, and I don't put them behind my back, that's failure to comply, disorderly conduct, failure to comply with a law enforcement officer, and that's a misdemeanor. If I run a few steps, that's going to be considered resisting arrest. Certainly, if I take any physical action toward that officer. The concern is we are adding mandatory minimums when we also have the option, I think potentially, and our prosecutorial folks may can add to this, when maybe we should be adding aggravating factors. Instead of saying there's a mandatory minimum, there's aggravating factors, because the first thing that we can already do is any crime that's not a crime of violence, which does not qualify for house arrest under 9732. The second part of 9732 says you can take any nonviolent offense and elevate it to a crime of violence based on a finding from the judge. So that's kind of, I guess, my concern in total, and it may go back to some of what Senator Turner Ford is asking, is are we actually hitting the target we're trying to hit, or are we taking away the flexibility from the court?
Good question. Do you, either of you have an amendment you would like to offer in light of that concern? Put you on the spot.
Well, particularly as it relates to section 297, 973, is that there still be a misdemeanor. Because I deal with this a lot in college towns, that there's stupid decisions made by a lot of times people who maybe consumed a little too much.
Right.
That would fall under this, and rightfully so. But to say that's a felony, what we're gonna see is a lot of charges amended back to disorderly conduct.
Right.
But I would like to see 9793 have the misdemeanor portion. And then if we add some aggravating factors, I don't want to offer a conceptual amendment, but I'm offering a conceptual amendment.
Go
If
for it.
there are aggravating factors, if there's a subsection B that's a felony, because we do that with a lot of crimes.
Under 97-973,
That's correct. Yes.
section 2. Okay. So would you restate the conceptual amendment? I think Ethan's jotting it down as we go.
That we reinstate the misdemeanor language, that there's a misdemeanor version of resisting arrest. But there are also would be a felony version of resisting arrest. That would be based on aggravating factors.
Such as,
Physical violence, such as, the determination, obviously somewhat is with the officer, but we don't want anyone laying hands on our officers.
right,
But there's a big difference between, I tried to scoot away because I was under 21 and I had beer and the law says I can't. And then I ran and I got caught versus I actually put my hands on an officer.
okay. Question, Senator Wiggins.
Yeah, well, may I offer this up? Because I think I know where you're going. So within the criminal code, that line generally is serious bodily harm. And so what I think you're maybe saying is, and I will say I agree with you on the misdemeanor, that if the resisting arrest results in serious bodily harm, then that becomes a felony with a 2-year, because that delineates between, if like the drunk college student who just resists and they end up, but I've also seen where, they end up sending them as a felony and there's no harm whatsoever. And what the serious bodily harm does means that the state has to prove that harm occurred to the officer. And there is actually law that defines what harm is in there. And so I think I agree that with that, I'd be prepared to offer up an amendment.
And I'm very accepting of that, as well as we already have all on the books as it relates to simple assault of a police officer. There's no such thing as a misdemeanor simple assault of a police officer. Any assault of a police officer is already a felony. So I just, that would be my concern, but I support Senator Wiggins and the amendment, or if he's supporting me in my amendment. I don't know.
Finish yours.
Well, then my amendment would be that the language as drafted in section 2 be restored to current law. And then we add, I guess it would be a subsection that if it results in serious bodily harm, then that becomes a minimum of 2 years, or I guess not more than 2 years, and thus becomes a felony.
Okay. Senator Sparks, did that make sense to you on your amendment?
Yes,
So it's
for sure.
basically amending the amendment. That's what we're
Yes,
talking about.
That's correct.
All right, Senator Hill on the question.
Yes, just a question, really a reiteration of what we're putting back down to a misdemeanor. On lines 53 and 54, it says it shall be unlawful for any person to obstruct or resist by force or violent threats or in any other manner. So they can still resist by force or violence or threats. And it could be a misdemeanor under this amendment, correct?
Correct, but that creates the force that makes it resisting. The serious bodily harm, this is on the amendment to the amendment, the serious bodily harm makes it the felony. So to Senator Sparks's point, if you're being arrested and you just pull away, that's force, okay? And that's a misdemeanor. And if if under the amendment as discussed, if you pull away and you turn around and hit the officer and it creates a black eye, that is serious bodily injury that then rises to the level of a felony. I think what Senator Sparks is getting at, which I think most people would be concerned with, is that if you simply pull away, does that justify you going to the penitentiary for a felony and everything that goes along with that?
Yeah, I understand what you're saying. So even if they punch an officer in the face, they can also get charged under the red, white, blue law, correct?
Which one is that? I'm not sure.
The first
Yeah.
responders law.
Injury to the,
Yeah.
injury to
Yeah,
the-
yeah,
Yeah, so,
that's right.
so there's still an opportunity for a felony, and does that one have a mandatory? Oh,
we can look that up.
yeah,
I think it does.
okay. Okay, that answers my question. I would just want to make sure that there's some other way to charge them if they, punch somebody in the face, and I just don't.
Well, I
consider-
guarantee you,
I
if
don't
they punch an officer in the face, they're gonna be charged with a felony resisting arrest.
Well, I don't see where punching them in the face would rises to serious bodily harm, but I think it would trigger that other law. that
Well,
we
and
already
that's,
have.
I will tell you, unless the law is changed, my recollection is a black eye is considered serious bodily harm.
Okay,
But what has happened in the past, and there's law, is that nobody had anything and they couldn't prove it. It's about what can be proved. And if you can't prove an injury, then you can't get the felony.
okay, thank you.
So there has to be, somebody has to testify that there's an injury.
Okay, thank you.
All right, Senator Simmons had a question.
Thank you. Thank you, Mr. Chairman, and I'm sorry I'm coming in at the end.
No, you're good.
Generally on the bill, and I see we making amendments, increasing penalties in various areas.
Yes, sir.
Do we have any data-driven information as to why we're doing this? Like, do we have information from the Prosecutors Association, from the State Public Defender, or even from AOC that would give us a reason why we are considering the proposal?
Yes, sir. And yesterday we passed out a list of a lot of the carjackings and the stolen vehicles in all the various counties. And what it showed, and we'll try to get you a copy of that if you didn't get a copy yesterday, is this particularly in the metro area, the highest was Hines, the second highest by far was Madison County. And then there were some other pockets around the state where you're having these issues, but largely it's become sort of a endemic issue to the metro Jackson area. We're trying to address that.
But to add to Senator Sparks' point, there is nothing about increasing minimum penalties that will, one, deter crime, and two, that will take away the discretion of the judges and the prosecutors on making recommendations based upon the facts of each case. So what's happening is when you come to the Delta, I mean, based off the range that's already in existing law, my prosecutor may make a recommendation on the upper end of that sentencing range, and that person may be actually convicted of that. When you go to Senator Sparks' area, based upon the facts, based upon who he's representing, they may work out something on the lower end, but it's all factual driven.
Right.
And so I guess that's just my concern, Mr. Chairman, that increasing the penalties, one, does not necessarily deter crime, but then also there's nothing that we could do to take away the discretion of prosecutors making recommendations and or judges who ultimately will make the determination.
I understand your concern. I think it's a good point that you raise. I think Senator Hickman raised a similar point in the meetings yesterday. I can say in response that over the out of session period, I know the Lieutenant Governor's office has been working with the local Hines County prosecutors, staff, getting lots of information from them. Some of that was in conjunction with the whole Capitol Police and the CCID district. So they were looking at a whole variety of issues, but some of these are the issues that sort of rose to the fore as something that really concerns a lot of the residents in and around the Jackson metro area. So I think this is an attempt to address that. It certainly may not be the silver bullet that fixes all of this, but it's an attempt to try and address some of the spikes in crime, particularly as it relates to cars being stolen, carjacked, fleeing from officers as a result of the carjacking situations here in the metro area.
Thank you.
Yes, sir. Any other questions? I think we're on the amendments, to the amendment still. So any questions for Senator Wiggins or Senator Spark on their consortium of an amendment here? All right, if not, all in favor, say aye. Any opposed, nay? The ayes have it. All right, back to the, I guess it's as committee substitute or as amended, whichever y'all prefer to call it. Any questions? All right, for motion. Okay, title fees do pass. Committee sub, all in favor, say aye.
Aye.
Any opposed, nay? The ayes have it. The ayes have it. All right, thank you for your work, all of you on that. I appreciate y'all continuing to make these bills better as we go along. We're gonna skip around a bit. Senator Boyd graciously came with like 10 minutes notice this morning to address a bill that she has filed 2346. It's kind of towards the bottom of your packet, and we will recognize Senator Boyd. And sometimes they ask for us to speak into the microphones, even though they don't really amplify that much, because it helps the people watching online to hear you speak better. So if y'all don't mind grabbing her mic.
Thank you, Mr. Chairman. This bill, really, I'll be honest, came to me very late last year, or actually very early this year. I was meeting with one of the senators from Louisiana, the pro tem there, and one of the things that she brought up and really encouraged us to look at was a bill that they had passed last year in the Louisiana legislature. And it had passed unanimously, I'm told, from both chambers in the Louisiana legislature. And one of the issues that she brought out, she's a very big advocate on human trafficking, really the prevention of that, and has kind of looked in depthly in that. And so one of the issues that they kind of looked at was that there is virtually no age verification in pornography sites. And as we all know, the world has changed. Used to, when we were growing up, I'm showing my age here, if you went to an R-rated movie, you had to be of a certain age, or your parent actually even had to accompany you in there. There was lots of age verifications for things that we do. We know that we don't let people get alcohol before the age of 21, cigarettes before the age of 21. And but unfortunately, this phone right now, your children that are in their teen years and younger than that, all have access to pornography at their fingertips. And I have to tell you, I really had to do a little bit of a deep dive into pornography. And I passed these sheets out to you today because I was just a little bit shocked at the amount of pornography is out there, how prevalent it is among our teen population, but also too, you'll see in sections 13 through, we go through, and we don't typically do this, but I thought it was important in this bill through 26. We list really here what the intent language is in the bill, because it goes to why this is a particular issue that the legislature needs to address. And it goes through what happens really, what pornography contributes to with the issue. It's been interesting. I've had a number of psychologists actually reach out to say that this is an important issue, particularly for our young teen men and our young teen women, that it creates a hypersexualization, and it leads to a number of things, including self-esteem, body image problems, and sexual activity at younger ages. And it increases the desire of adolescents to really engage in that behavior. It also can act, I did not realize this, but it impacts brain development and functioning, and it contributes to a number of emotional medical illnesses. And so for those reasons, I think it is important that we kind of look at doing just a simple age verification process. This legislation is unique in that it provides a simple remedy for damages against commercial entities who distribute material harmful to minors without performing a reasonable age verification process to verify the individual's age that's seeking to access the material. And just how prevalent that is, if you will look on the handout that one of my interns from Ole Miss provided for us, she has an interest in this. There are 6 billion visits to the top 5 pornography websites accounts per month in the US. That's the huge amount of it. And if you'll see that the pornographic websites that garner more internet traffic than Twitter, Instagram, TikTok, and Wikipedia combined. So there's a lot of use of this. So what we've done is in section 2, we have given the definitions. We very much modeled this after the Louisiana law that they've just enacted and went into place in January. And we have some pretty significant definitions there that I won't read out to you. And then we have also put some caveats in here that this obviously does not apply to news gathering organizations and material that is literary, artistic, political, or scientific in nature for minors. So we're not talking about banning art sites that look at drawings that are artistic or anything in nature like that. Section 3 puts the kind of teeth in the bill, and it puts it back on a commercial entity that knowingly or intentionally publishes this. They have to do in 107 through, we go through their beginning as to what they also do once they obtain this age verification. It requires those companies to delete that private information from their system.
Can I break in for just
Yeah.
a second? Because I know one question that I've been asked, I'm sure maybe people wondering, how does this work mechanically? Assuming you want to do this, how do you technically go about enforcing this age verification on
Well,
these sites?
Yes, and so the sites, I'm going to be candid right now, are just starting to do this. They had to in January 1 just start doing this. So at this point right now, that you can put in your government, your identification of which they have to remove from their site after the access has been granted. Also, too, there's some commercial age verification systems that are out there already. And so you can use those commercial age verification system as well. It puts it on the responsibility of the pornography site to capture all of that data. So there's no cost or anything like that to the state on this.
And is that for pay sites only or for any site for profit, or I guess, I don't know if you call it not for profit, but not charge, in other words, to the end user?
Right. So most of this, and I've had a couple of questions on this, like for instance, YouTube, Google, any of those sites like that, which Google's a search engine, but any of those sites like that don't conform with what is fit within what a pornography website is. We're looking at material that you have to have over a third of that site has to be dedicated to those things that are considered what we can kind of labeled as pornography here in that site and fits those definitions.
Thank you.
Yeah. So that is what basically it does. It puts the responsibility on them. We've exempted the search engines. We've put no liability on them. This is strictly for these sites. And the majority of sites are, and the sites that I have found in a brief look, and I did do a brief look, the sites that I found, most all of them are for pay sites. So I don't have subscriptions. But anyway, those are for pay sites. I didn't find any like publicly available site that was not a for pay site. That is just in my rudimentary research. So anyway.
All right, Senator Simmons.
Thank you, Mr. Chairman. I may not know enough about it, but I guess a long time ago, when I visited one of these sites.
Just hypothetically speaking.
Yes. But so I guess my question is it insufficient right now for them to say, what's your age? And then you have to go through a series of clicks before you are allowed access to the site. Are you saying that that's insufficient?
I'm saying that most of the sites that are out there right now don't even require this really click. And I am saying that it's insufficient. They need to do some verification, just like you would. I mean, we require more verification from the package store that is going to deliver you alcohol than we require in these foreign sites. And I'm going to tell you that harm that for these children can be pretty significant. So so we need to make sure we do a much better job of what our children have access to.
It's from the person who's viewing the site. Isn't a concern that they have to provide more information now to just get access?
Well, and that's when we put the responsibility back on, you can see in this, there's a significant responsibility on those sites to make sure that they protect private data and actually get rid of private data. And we put some liability on them if they don't, make sure that they get rid of somebody. Remember that we were all familiar with a number of years ago, there was a breach by a, website that where people clicked up for various activities. And so that public information was made up, was out there. This is where we put a big responsibility on those sites. If that information was leaked or made available, then they would have some responsibility on that to protect the person's privacy.
Well, but last comment, Mr. Chairman, I have a 9-year-old and a 4-year-old, so I certainly want to do everything to protect children. But to me, the simple answer to that is parenting. I just think this is a slippery slope on, we're talking about holding companies liable for. Just scared about legislation like this.
Well, this is not our personalities. We appreciate everybody here at this table. But you've got to vote the way you think is best. Senator Hickman?
Yeah, just a couple of questions. One of the things that, and Senator Boyd, you and I have discussed this extensively. One of the things that I think this morning in particular, when you say there's liability on the company if they don't dispose of this personal information, what is that? Does it allow a private cause of action, or is there some state penalty or fines placed in there if they're not properly disposed of this individual's personal information that they've had placed inside?
The way that Louisiana legislation that we've modeled this after does, it is not state responsibility. It's purely the companies. So it rises to a private cause of action. And we have spelled out what that private cause of action is. So this is individuals have a cause of action under that for that company if they don't properly dispose of and create confidentiality of that information.
But what is the damage itself? I'm looking at lines 113 and 14, I guess.
Yes, we
112, 113, and 114. So
we have made a general statement of damages. So any remedy that's available in civil court through any tort or anything like that would be the traditional damages. So we have not spelled out any specific damages per se. It would be just the general damages that are available under traditional civil remedies.
okay, so no criminal penalties at this point.
No criminal penalties, just traditional civil remedies.
All right, questions, comments?
I was.
Senator Hickman, I'm sorry.
Tag team.
Yeah, go for it.
Question. So I guess my next question is what I thought when we talked, and that's just my hearing, that the site had to be 2/3, but it has to be 1/3. What is that? I felt very good about the 2/3, but 1/3.
And we open to, I probably would, and I listened to the hearings kind of in Louisiana, and I listened to those that are what kind of they had done in that. And so I followed what they've really done in Louisiana in that matter. But if you've got a site that's pretty much of a 1/3 of that is being used for that, that's when really they felt like it rose to the need of making sure that that was being protected from minors. So that's really where it came from on that particular thing. So.
And one final question. So does they just have to have some form of verification? They don't have to, like, I mean, I don't know if people are getting fake IDs for porn, but if there's, I mean, do they have to verify that this thing is real as a, like whatever verifications they have, as long as they have it, if that's sufficient to meet the burden that they have?
I think so.
All right, Senator Hill.
I briefly like to speak on the bill.
Sure. Are there any other questions about the bill first? All right, Senator Hill, you're recognized to speak on the bill.
Thank you, Mr. Chairman, and I'll be brief. I absolutely support trying to limit the access of pornography to minors and appreciate the work that's gone on this bill. But I would also like to mention that there's bills pending before this committee and in the House that address pornography and obscene materials in school libraries. Because we know that we have obscene materials in school libraries and we have an exemption in statute that allows them to do that. And so some of the bills that are pending would affect school libraries. So I think if we're going to affect, websites out there, we certainly need to look at some of these bills regarding our own public school libraries. And also we have bills pending. Right now, we know through public records requests that we have children as young as 11 having sex transitions facilitated through state funding and through state institutions and through Medicaid. We know as young as 11. So I would urge the committee, while we're trying to protect children, to please let's consider these other bills that we have pending in the House and the Senate that address pornography and obscene materials in school libraries and address the state facilitation of gender transition for children we know as young as 11. Thank you.
Okay. Any other questions for the author who is again gracious enough to come here super early this morning? Senator Barnett.
Thank you, Mr. Chairman. What happens in the event, Senator Board, where a young male or young female uses their older brother or their older sister's ID to gain access to this, and something seriously happens and find out and they go to court in the whole 9 yards, but it was not that, and this person now is brought up on charges that they had no idea of what was going on.
Well, I think Senator Barnett, you're in the same situation when the child also uses a fake ID to go buy beer. That at that point, that child uses false identification. And so at that point, that child, right now though, I will say this, there's nothing that limits that child from, they don't have to have any age identification. So, so you're in the same scenario as just like you would if they had used it to buy cigarettes or alcohol at this point.
Understand that, but there are times when facial recognition is also, you have to show your face, but on this, then all they have to do is just put in a name and a birthday or whatever, and they gain access. Is there going to be any type of facial recognition required also?
Well, we have put in what is technology available right now in making sure, if you look at the definitions on this, we have, and this really, we're encouraging the companies to really step up to the plate here on this, is that we have put in 2 options for these companies. They can use the government issued identification, and then they can use any commercially reasonable method that relies on public or private transactional data, because there are those professional identification programs and companies out there that are a little bit more technology savvy that would cover what you're talking about right there.
Okay. I'm not against the bill, and
Yeah,
I just want to make sure
it's
that
strong.
that it's strong, that everybody that's intended to be protected is protected, and
Absolutely.
nobody is prosecuted for something that they were not aware of. So I just want to make sure that while we are trying to prohibit all of these things, that we're also trying to protect those other individuals out there as well.
Yes, this does not create any type of cause of action for the brother whose ID is not what is created in this. This puts the responsibility on these companies to make sure that they have put a process in place that tries to protect our minors from getting access to that.
Senator Simmons asked a question a minute ago, and it went specifically to parenting. So at what point in all of this legislation that we do, when we're talking about our children or our youth, I see that we are trying to hold everybody else accountable for things that we should be doing as parents. Is there any legislation out there that you know of that addresses how parents should be held liable for some of the same things that we're trying to hold everyone else accountable for?
I think we have a whole youth court system that parents can be pulled into. So this though, I mean, look, I am all for holding anyone and everyone accountable, especially parents. I'm the first one to do that. But at this point, the access that children have with these phones, it's something very, very different than we had when we were growing up. And when I've had the number of calls that I've had just by introducing this legislation from a psychologist who said, look, this is a very serious issue. I think then we have to, as legislators, step up to the plate and say, how do we help parents in this regard?
All right, good questions. All right, for a motion, Senator Sparks,
Title sufficient do pass.
all in favor, say aye. Any opposed, nay? The ayes have it. Thank you so much, Senator Board, for your work and for coming early this morning to do this. All right, we're going to try to tackle at least one or two more of these, and of course, we'll meet again next week. But the next bill we'll take up, Mr. Sage has been patiently waiting in the back. Senate Bill 2298 deals with bail agents, revised the procedure for determining in municipal and justice courts. Mr. Sage, if you'll take the seat there and speak to the microphone and give us a very brief description of what 2298 does, please, sir.
That last part.
Very brief.
I'll be very brief. This bill is a bill that kind of fills in a gap in the Supreme Court. The law is, there's two code sections. One is municipal court, the other is justice courts. The municipal court section has had for a long time a provision that allows the judge to take care of kind of setting a bail amount, appointing someone that can say, this is what your bail is, and you can get out of jail. We've had a lot of litigation. Supreme Court changed criminal rules in 2017. And so there's some provisions in there. So we're trying to fill in the gap, a couple of gaps. We're trying to make sure we're not violating kind of recent case law and what the rules say. So the idea here is that if you get arrested and the judge is taking care of basically setting a bail schedule, and I'm going to use those terms. That was the term that created a lot of issue, but the courts basically now said that's okay. You have to have some other due process and things like that. So what the rule says is you should be before a judge within 48 hours and the judge sets your bail. What we're trying to do is say, okay, if you want to get out before 48 hours, you can waive your right to see the judge and post the bail that the judge has basically assigned for that particular crime. So you're waiving your right. So that's the key part of this. And then you can get out of jail right away.
And does that vary from jurisdiction to jurisdiction? So you're talking about when the judge sets a bail schedule, that's not like the Supreme Court sets the schedule, it's each of the various jurisdictions?
That's a good question because I mean, the schedule is set within some bond guidelines that are in the rules.
Okay.
So the judge is to a certain extent constrained, but they're pretty broad guidelines. So it's in the discretion of the judge anyway to consider different criteria, go off or just something else, but whether you're a flight risk, the crime is violent, so forth and so on. So the idea of the bail is to guarantee that you show up in court. So if a person is out on bail, let me say this, I represent the Bail Agents Association, you all know that. So they get you out of jail with a bail bond, but there are several other ways to get out of jail, post property or some other type of security, or you can put up a cash bail, get out of jail. It's not some kind of thing that's kind of making something exclusive or whatever. So the idea is that you get out of jail as quickly as possible if you do that. There's a lot of language in here that are protective language in view of some recent litigation, but the recent litigation basically is fine with setting a bail schedule and getting somebody out of jail like this. There's also some underlying language, and I'll say this, there's a provision on domestic violence in the justice court section of the law. And we lifted it out, stuck it in the municipal court section. We felt like that was just something that needed to be there. Doesn't have anything to do with bonds or whatever. Then the procedure that's in the municipal court for setting the bail schedule and appointing someone and so forth was not in the justice court section. So we lifted it out and put it in the justice court section. There's a lot of underlines there that are necessarily new law.
Great. Questions for Mr. Sage. He's very engrossed in this in detail, so he can answer your questions. Senator Hickman.
Just one question. Try to peruse and read through this, but when you say they give up their right to see a judge, they don't give up their right to any other remedy. that time, and, you know, in the 48-hour period, if they want to see a judge prior to that and they just pay the bond by the bail by the guidelines, do they forfeit any other rights to this process, but for the right to see a judge within 48 hours?
Yeah, good question. And no, the answer to that is no, they don't forfeit anything else. And there's actually provisions in the law there on saying that if you, like what the judge has said, that you, and this is kind of follows the rule that you got 48 hours, or you file a motion within 48 hours following the motion. Any rights, it says waive your right to see the judge.
Now, this is
I
not
think it's
a
already-
requirement, though. I mean, if you want to wait and
no,
see the judge within 48 hours, you can do that too, right?
That was the kind of the crux of the problem with the rules is it says you wait 48 hours and the judge says you pay. So that's the only way it can happen. So like I said, in the municipal court section, there was always been this provision, or maybe we put it in there years ago. Y'all put it in there years ago, where judge could make some provisions for someone else setting the bail. The problem with the bail schedule or the challenges in court that created some of the issues were people are saying, you're saying this person is, his bail is going to be $3,000 and they can't afford to get out of jail. So the only reason that they're in jail is because they can't pay that amount in bail. Protections in there for that also, that's not the only reason you hold somebody in jail because they can't pay the bond. You can't do that. And that was being done. That was an issue. So, you know, we kind of tried to address that too. So this is, like you said, Mr. Chairman, is an option. If you want to sit and wait on the judge and not pay the bail, you can do that. This is for a situation where somebody wants to go ahead, set a bail. And you can imagine if somebody had a child that got arrested on Friday night and they're it's an option.
Gotcha. All right, Senator Simmons had a question.
Thank you, Mr. Chairman. I guess my question to Al, I know you always worked a lot regarding bail. Did you run some of your proposals by? They seem good, and I understand what you're trying to address, but I just know the Supreme Court worked really, really hard before they released the last rules of court around July 1st, 2017. And they take proposals and amendments every year. Have you run any of this by them?
We have filed a motion with the court to basically do the same thing that this does. I can't remember exactly, Senator Simmons, what year we did this, but it's been several years. I'll note that it took the court 10 years to change the rules. And I have a feeling that it may take a while for them to consider. So this is not, and I want to be clear, because I know some of y'all may be confident and you may get a question. This is not to interfering with what's in the rules. I mean, they could do this, but it may be a while. So like I said, we're kind of filling in a gap with what's in the rules. We're not stepping on their toes.
All right, Senator Wiggins, I think had a question.
I wanted to speak on the bill.
Oh, good. Any other questions for Mr. Sage? All right, Senator Wiggins, you're recognized.
Just real briefly, and Mr. Sage has hit the nail on the head, but also I wanted to make clear because there could be some language in here that people have questions about. Many people misunderstand bail, okay? And many think bail, and what gets used to your question throughout different jurisdictions is bail is used to hold people in jail, and the guilt is assessed using bail. Under the Constitution, both US and Mississippi, that is not what bail is for. Bail is to ensure your appearance at court. And there are places in this state who I guess I'll be generous and say artificially high bail so that people knowing that they cannot make bail, and that they cannot do it. And what this language is doing is setting what I would call a standard for municipalities. And most of your bail, if you have a lot of cities, are set in your cities, which are city judges. And so I appreciate what the bail agents are doing. And this also will keep us out of litigation because you're not setting artificially high bail. And so they have to look at all these different factors to make a determination. And yes, I will proudly say that it puts it on the judges to make that determination. But what is going on in this state, and I don't think it's necessarily intentionally, but you have people being held in jail for the sole purpose, knowing they cannot make bail so that they won't get out. Now, we all want violent criminals kept in jail, but there are provisions that need to be, for example, the Mississippi Constitution allows bail to be denied if you've committed a crime while you're on probation or you've got another thing, and all you have to do is do it. But it causes issues, and we're violating people's constitutional rights. And so I think what the language is doing is that's why there's been litigation. That's why there's been a schedule. And so this is trying to accomplish those different things with that. And so I would encourage passage.
Excellent remarks. Thank you. I wanted to recognize a friend of mine and Senator Wiggins is Vicky Lowry. She was in law school with Bryce and myself, and just a day or two ago, and Jason
She's
White.
smarter than all of us.
She has far exceeded the rest of us in the class, but thank you, Vicky, for being here this morning. All right, any other questions on the bill? If not for a motion, Senator Simmons. House to pass. All in favor, say aye.
Aye.
Any opposed, nay. The ayes have it. We're going to try to tackle one last bill this morning, 2347. I'll recognize Senator England, I believe, has Vice Chairman England has that one. It's dealing with hospital police departments down on the coast, I think. Yes.
Yeah, that's correct, Mr. Chairman. Thank you. What this bill does, if you'll see, this is a very limited bill that would allow any privately owned hospital that purchases a hospital is previously publicly owned, and that hospital had a police force in place, a police department at the hospital. The privately owned entity may choose to continue to have that hospital. This is very limited right now. I have had discussions with folks that may want to see how this works out and move forward, maybe with other hospitals. But these individuals are typically retired police officers that are very highly trained in de-escalating situations that arise at hospitals. So it's a very important bill for my community. I'm happy to answer any questions, but that's essentially what it does. It kind of grandfathers them in a hospital in. If they currently have a police force, they may continue to have that even if they are purchased by a privately owned entity. No. Yes, thank you, Mr. Chairman. Yeah, no, this does not deal that the retirement is handled by the hospital. The police force is funded by the hospital should they choose to do so. There's no state or local monies involved in this. So yes, they don't they're not in the retirement. The retirement is up to the hospital if they choose to offer that.
Better of an example. So obviously there's an example here that led to this legislation. Tell us what happened and why you need this if you don't.
Yes, thank you, Mr. Chairman. So currently there are, I believe, 4 county-owned hospitals or so that have a police department. There's some of your larger hospitals. You've got Forest General, UMC has one, and the Singing River Hospital System down on the coast has a police department. It's something that our local police force, our individual police departments in our cities, our sheriff's department they're all supportive of this. Because it's very helpful to them. They don't have to use resources to be there. It's also something that they've mentioned, and they've all signed a letter off on this situation, trying to keep this police force grandfathered in for now, because there's an RFP out to possibly have this hospital be purchased. That could be a private entity. And if you'll notice on line 27, this says that they may continue the hospital force, it's not a requirement. There's no shall involved there. So it just allows the option to continue on that. I think that may answer your question, Mr. Chairman.
Yeah, Mr. Vice Chairman, I don't particularly mind the bill, but I just need to understand something. So if it's a private entity that purchases government hospital and they're gonna have a police force, I guess my question is, one, what would be the difference in this police force and like a security agency? And then where do we go with indemnity and stuff like that if this is no longer a quasi governmental entity, but a private entity having?
Yeah, thank you, Senator Hickman. And throughout the bill, this is addressed with the duties and the abilities of this police force. They essentially have the same capabilities as a regular police force to enforce laws that are on the books. Now, they can't, and they would have arresting authority, but they would not have the authority to arrest someone for violating a hospital policy. They act just as a police department. There, if you'll notice on section on line 38 through 42, in the exercise of their authority, they are subject to the conditions and restrictions established in this section and also by those promulgated by the Department of Public Safety. So there is that built in. So they do have to look at that. And look, that's mentioned throughout because that was a concern here that we wanted to allow them. So 64 to 65, you'll see hospital police officer may exercise all the powers and authority of a law enforcement officer. And then if you look throughout, sorry, 50 to 50. Thank you, counsel. Yeah, 50 lines 50 to 52. You know, you have the same accountability requirements as a public police department. So the accountability is built in there. And look, while I'm looking for this other section, I want to mention here while I'm perusing through the law, through this bill, there are other states that have done this and they've had success. So we're not doing anything that.
And I just want to say that
Yeah.
my concern here was just making sure the hospital, okay, especially with the whole indemnity thing. Where do we file with that?
So that's built in lines 117 through looks like lines 124. You'll see it says a hospital officer shall not be subject to civil or criminal liability unless one of the following applies. And then it's built in that, you know, if they act outside of their scope of employment there, if any of the acts are omissions were malicious or in bad faith, and liability is expressly imposed upon the hospital police officer by any other provision of this code. So there is and that is built into the bill.
And final question, they have to have all the same training and all of that as any other police officer.
That's right. As a matter of fact, they have to have additional training to deal with de-escalating situations that deal with hospitals. You know, we have we're trying to work with addressing mental illness concerns here in the state. And we also see police officers and police officers, if they pick up someone, a lot of times we don't see the drunk tank anymore, so to speak. They're dropped off at hospitals. So you know, this is a big safety concern for our hospital in particular.
Thank you, Mr. Chairman. I'm like you, Mr. Chairman. I'm just thinking about the practicality of this. So I just got one or two questions. So could an officer leave the hospital and on his way home make a traffic stop in the city?
No, this only applies within the confines of the hospital campus and the roads directly around the hospital facility.
So any other police powers and duties and responsibilities of the local municipality, police department, and or the sheriff's department in the county, they will not be performing any of those duties and responsibilities.
That's correct. This only apply again. This is only at the campus of the hospital.
Okay,
Yes. Thank you for that question.
Thank you, Mr. Chairman. Two questions. The first question is, section 5. It states that the legislature may appropriate funds. Is that pertaining to the operation of this police department?
So I believe that's just carrying forward a previous code to get us to that section of 289 to 291, which is an addition. We needed to again, where you've got this hospital defined through there. This specifically says that a hospital, as provided in the section that we're seeking to pass, shall pay the expenses, including tuition of any of its officers designated. So actually this says that they will pay that. So that code was brought forward to specifically address that concern that this isn't going to be paid for by appropriations from the state legislature. Is that correct, counsel? I believe that's correct. They will pay for the training.
And so when I think of a police department, there, any affidavits or arrests that they make are prosecuted in a certain court, which court would handle or manage their arrest?
Yes, thank you for asking that question. So what currently happens and what will happen if a private entity chooses to continue with this police force? They use the municipal court in our cities. And any fines or anything that results from violations goes directly back into that system. So they're not using the courts and taking any fines to put into the hospital. It's just as if a police officer brings someone in the municipal court and any court fees or anything associated that is charged to the party that goes right back into the municipal court of these areas, or the county court if that's where they end up.
So that's currently how it operates, I guess, in the system that you all have. Would these officers have the discretion to take these cases to municipal or justice court?
I believe that's, and I'll have to check with council. I believe that's already outlined in other areas. Same if a police officer, say if a Pascagoula police officer arrests someone, it would be whatever court they go to in that situation. So they're within a jurisdiction there of the courts as well, just like other police departments are in jurisdiction.
Right, police go to municipality
Mhm.
and the county deputies would charge or file their affidavits with the justice.
That's correct.
But if this is a police department,
Mhm.
do we need language to make certain that they would have to file those charges with the municipal?
I would have to ask council on that. Yeah, yes, that's not addressed in the bill currently, Senator Turner Ford. I would be happy to entertain an amendment or to look at that with you before we get to the floor. If we move from committee, because I would certainly be willing to work with you on that to make sure that we outline that and clarify that issue. Yes, and just like so they have to work with the prosecutor too, is what council is just now telling me.
And so why would we want to give a hospital that is going to come under private ownership such as North Mississippi Medical Center, Baptist? Why would we want to put them in a position to have a police department when they can go out and just hire a security company like all of the other hospitals are required to?
And again, that's a very good question. The answer is that the training that's involved and the fact that we are there's this is a very, very narrowly, the bill is very narrowly tailored to apply to hospitals that already have a police force, and the training that they've already put into place with these officers. And so that's really the answer to the question there. There's really only one hospital I know of that this could apply to, and it would be something that we could look at in other instances. And I think that we could look at how we can assist maybe with other hospitals. And look, other county hospitals in the state are able to do this already. They just aren't doing it. These are just your bigger hospitals that have done that to help with the de-escalation of the process.
So which hospital is this?
It's Singing River Hospital System is particularly who I have worked with in coming up with this bill. And the language in the bill, I believe we looked at West Virginia to get some of the language for them, and some other states that have done this. I believe there were around 30 states maybe that had already done this, but yeah, so it's working in other areas as well. But again, this is just a very narrowly tailored bill to assist with any hospital already has a police force right now to continue with that if they are privately purchased.
How many beds?
How many beds do they have at the hospital? Shoot, I don't know the answer to that, but there's 3 campuses. They have Pascagoula Hospital, Ocean Springs Hospital, and Singing River Gulfport, which was previously, I believe, Garden Park. And so it's a large hospital system. And again, the police departments in these areas have worked very well with this department and have asked that they continue to do this, because otherwise it's going to pull resources from the communities to deal with issues that are showing up at our hospital.
How?
I'm sorry?
How would it pull resources from the community if they can hire a security team to operate and manage these facilities?
Yes, well, because the security team doesn't have arresting authority, they don't have the ability to act as a police department. They're not able to do that. And these are a lot of times individuals that are being dropped at the hospital or showing up at the hospital that may need help with mental illness or mental issues. They may be people that the police department has picked up and is not going to bring to their system for one reason or the other. So they bring them to the hospitals. Because, liability issues that arise now when you bring someone to jail that may need to have gone to a hospital instead. And we've also seen, even in this town, tragically, just I don't know if it was last year or the year before, where a officer was able to step in and save the lives of people in the hospital. And we're starting to see, unfortunately, with the issues that we're having, that we're trying to address it with other laws as well when it comes to mental illnesses, but our hospitals are just not as safe, unfortunately, and this has already proven to be a system that works, and so we're trying to keep that.
Thank you.
Yes, thank you, Senator Turner Ford.
Thank you. Yes, thank you, Mr. Chairman, to speak on the bill. And I don't want us to get it too complicated. Look, this is just trying to keep things as they are. And as Senator England has said, your bigger hospitals, this is a safety issue. When you have right now, you have mental health situations that go on. You have, honestly, there's been cases where people come in with a gun into the emergency room or whatever. It's a volatile situation. And so these hospitals have a police force that does, and when something happens, to Senator Turner's question, it goes through the proper channel. So in the case of Singing River, it's in the city limits of Pascagoula. So it will go to the Pascagoula Municipal Court. And if a person commits what would be considered a crime, it's handled like that. The issue is, we also have pending before us this community hospital bill where allowing community hospitals and other hospitals to expand, to merge. So this is an oncoming thing. And this is allowed in Singing River Hospital's case. They already have a police force to protect patients and to protect them. They are up for sale. That's been public. And so what is just trying to happen is to allow this force, not giving them anything new or anything like that, to just remain there to protect the patients and the nurses and the doctors in these situations. And it could be coming in the situation with the community hospital bills that we're going to be discussing this session, because as Senator England said, there are others in this situation, and it's just simply trying to keep the status quo in light of what we're addressing with our community hospitals. And with that, Mr. Chairman, I would encourage passage, and my motion would be title sufficient to pass.
So to make sure I'm clear, and thank you, Mr. Chairman, how is this different from just authorizing these hospitals to have substations at these different facilities?
Well, when you use the term substation, that's the connotation that this is a police department. This isn't a quote police department that you have a substation or effectively an arm of the police group. They are police officers that they've and remember, this is a community hospital. Okay, so they are there doing their job. And so if I understand your question, it's not a substation. It is a force to protect the patients, the doctors, and the citizens.
So then my follow-up question, well, this is a different question. And I'm thinking about another issue where nothing would stop this hospital system from coming back later in another session and saying, now we want to create a hospital district or whatever it's called, where this police department now kind of ebbs into the community and begins to exercise power in other areas. I mean, we're hearing about that with the capital improvement district.
Well, that's
So
because,
so my.
Senator, with all due respect, that's because
would like
people
to
are being
finish.
murdered
I would like
and
to.
people are
finish
being
my comments.
carjacked around the Capitol, and the Jackson Police Department was not able, or were not doing their job. And I will tell you from that, I've had Jackson residents tell me they are extremely thankful for what this legislature has done. So it's about protecting the citizens.
And I believe that there are multiple ways that can be done. I'm just trying to understand why we are creating a police department for a hospital. And other hospitals in the state will not have that same authority or the capacity to do it. That is my concern.
Well, I don't know if they will have the authority. See, this is a unique situation because of where we are. And we're in this situation because of the crisis of our community hospitals. And if the question is, can Baptist, which is some completely private hospital, go out and we're giving them the authority to create a police force? No, that's not what this bill is doing.
All right, I'm gonna go ahead and refer from, I think, a lot of folks that at the time was, yeah, so there's been a motion made by Senator Wiggins, pass. Are we ready to vote? All in favor, say aye.
Aye.
Any opposed, nay. Nay. Yeah, so, Mr. Robert, thank you.
Hey, you're in county affairs today. I'm gonna try to get one bill out and then have the upward curve bill.
Yes. Sorry. You are not currently planning to meet it for unless I get directions. It's okay. I mean, but then something happens, so I hesitate to say no.